Good morning, everyone. Here we go. It is going to be the last day of the Karmelo Anthony trial. Thanks for everyone who is tuning in live or on replay. It is only 8:30 in the morning out here on the West Coast where I'm at, so I went without a tie. Apologize for the casual nature of today's presentation. It'll probably not be the only live stream we're going to be doing today about this trial. Where do we sit in the Karmelo Anthony trial? Both sides rested yesterday. They had the all afternoon off. We thought there may have been some possible discussions of plea negotiations. I'll talk about that in a moment here. And then I want to address some other issues that have been going on as it relates to some rumors floating around on X about the competence of the defense counsel and what their strategy may have been. Want to correct or clear up the error on that as well. Then we're going to talk about some pretty amazing developments in the courtroom today as it relates to closing arguments. So, anyways, for all of you who are tuning in right now, thank you very much. Appreciate having all of you on board. Again, my name is William Kirk. We are Washington Gun Law. I have spent 30 years of my life being a criminal trial lawyer. I have enjoyed most of it. However, I am predominantly doing content creation now, but I've tried hundreds of cases to verdict, both as a prosecutor and as a defense attorney. So I do understand the gamesmanship that is trial work. What I want to go through what happened in the courtroom first. This is interesting. Okay. This is the way it normally works in a trial. Okay. The prosecutor goes first because they have the burden of proof. Then the defense gets to give their closing argument, and then the prosecutor is typically given a little bit of time to rebut the closing argument of the defense because, as I said, they have the burden of proof. So hypothetically, this is just a hypothetical, if I were the judge, I would give both sides, both prosecution and defense, let's say 20 minutes. Okay, it might have been an hour, whatever. We'll use the time 20 minutes. Okay, prosecution, you get 20 minutes. Defense, you get 20 minutes. Now, the prosecutor would typically say, okay, Your Honor, what I want to do is I'm going to use 15 minutes for closing, and I want to reserve 5 minutes for rebuttal. Great. It's your case. I'll let you try it the way you want. But here's what the prosecutor did here. The prosecutor waived his closing argument, the whole thing. Now, does that mean he doesn't get to give a closing argument? No, it doesn't. What it means now is that all of those 20 minutes under our hypothetical that was assigned to the prosecution for closing now gets to be used exclusively for rebuttal. So when the prosecutor waives his closing argument, not his rebuttal argument, the defense ends up going first. So the defense attorney had to get up, give their closing argument, and now the prosecuting attorney has their entire allotted time for rebuttal, which means you get to start picking off everything that the prosecutor said. You get to start shooting things out of the sky like you're out there shooting clay. I do want you guys to know that the news sources that we are relying on in making these live streams and any video for that matter are linked up in the description box down below. Every other video that we have done about this horrific case is also linked up down below. Our predominant news source is NBC DFW Channel 5 in Dallas, Fort Worth. They've had reporters in the courtroom. I think they're doing a decent job of reporting coming out of the court. So let me give you some updates. This one is from about 43 minutes ago. And I want you to know that in this case, before we get there, the judge has given multiple jury instructions, including an instruction on the lesser included of manslaughter. Okay. Murder is the intentional taking of a life, where the intent was to actually take the life. Manslaughter is the engagement in reckless activity, understanding that there's a substantial likelihood of death or serious bodily injury, and choosing to go ahead with the act anyways. Now, a lot of people are going to be freaking out. Why is the judge even given an instruction on a lesser included? I will tell you exactly why, because if a judge probably does not include an instruction on a lesser included, that is yet another ground to appeal this verdict if it turns out to be a conviction. So the defense actually wanted also an instruction on negligent homicide. Negligent homicide is actually lower than manslaughter. Manslaughter typically requires a reckless act. Negligent homicide obviously only requires a negligent act. You can see negligent homicides on things where someone was looking at their phone, ran a red light, T-boned somebody, and that resulted in a death. That is, in many instances, would be considered a negligent homicide, okay? The problem here for the defense team is that the allegations and much of the evidence that has now been introduced at trial shows that this likely was an intentional act. So within that in mind, Judge John Roach explained that during closing arguments, the state will present their argument, blah, blah, blah. Okay. When closing arguments began, prosecutor Bill Werski waived his opening and chose only to respond to Howard's closing statements, Howard being the defense attorney here for Mr. Anthony. Defense attorney Mike Howard proceeded with his closing statement, saying that Austin Metcalf had no legal right to use force to eject Karmelo from the Memorial High School tent. Okay. Even assuming that in arguendo, assuming that to be true, he had no right to use force to remove Mr. Anthony from the tent. Okay, that's fine. That would allow Mr. Anthony to perhaps use some force to defend himself. The question is, does it rise to giving him the legal justification to use lethal force? That is a big hurdle for the defense to get over. Howard explained that Metcalf had the right to ask Karmelo to leave. He did, but that he had no legal right to put his hands on Karmelo, noting that Karmelo was in a public place. He reminded the jury of the importance of the jury charge, noting that defendants are innocent until proven guilty beyond a reasonable doubt. Okay, having been a defense attorney and coached a lot of young trial lawyers how to be defense attorneys, if your theory of the case is what's in the jury instructions, then you don't have a theory of the case. Okay, if you're sitting there wrapping yourself up in the jury instructions and that's all you really are talking about, that's not a good sign. You need to have a theory of the case. You need to have a story, a plausible story to explain to the jury. I get that there's burdens of proof and all that. Yeah, you want to know two of the biggest legal in America. Number one is the presumption of innocence, fat chance, and number two, burden of proof. Juries just don't get it. You can instruct them on it all day, all night. They're still not going to get it. Howard reminded the jury that they heard the track meets are social events, but that the memorial tent seemed to believe otherwise. Okay, that's fine. Again, none of this is getting to the point where it justifies the use of lethal force. Maybe these two guys got in a little bit of a fist fight. One kid got beaten up. We're in an entirely different situation. We also wouldn't be talking about this case, would we? Because there's nothing too juicy about that. The government wants this case to be about Melo could have just left, which he could have. Sure, he could have. I'm sure he wishes he did. Yeah, I bet he wishes he did. The state wants you to believe that he sneaked into the tent, Howard said. Multiple witnesses said he seemed friendly and they dabbed each other up when he was even waved over. Howard asked the jury to put themselves in Karmelo's shoes, saying it was raining, that Karmelo saw people he knew inside the memorial tent, and that he walked over and commented on crazy weather. He spoke about how the Metcalf brothers approaching Karmelo reminded the jury that they heard testimony that Karmelo said, "No one has a problem with me being here but y'all." Howard painted a picture for the jury of people surrounding Karmelo in a packed tent and described Hunter and Austin Metcalf getting more and more mad. The problem with that, good story, good theory. The problem is that none of the evidence really ever bared that out. Okay. It was like a little one-on-one confrontation between the now deceased and the defendant. And there was testimony of a slight shove from Metcalf to Anthony. That definitely was deduced through testimony. The problem is that's the only thing that was deduced through testimony. Howard painted a picture for the jury of people surrounding Karmelo in a packed tent, and that the brothers were physically larger. Do you turn your back? Howard asked. Where you can't defend yourself if their teammates jump in. Again, no evidence ever. If evidence was coming in that there was 7, 8 people surrounding him, all getting heated up, all making verbal threats to him, possibly, not saying for sure, but possibly this case could have gone a little bit differently. Howard told the jury that a shove, hit, or push is an unlawful use of force, and Karmelo had a right to defend himself. I will, for the sake of argument and arguendo, let's assume that to be totally true. I agree. If someone unlawfully pushes you, you do have the right to use some force to defend yourself. You do. Do you get to plunge a knife, though, through a person's chest in that situation? I don't see the legal justification for it. But again, that's me, and I'm not trying to tell you all how to think. I'm just trying to give you the stuff to think about. He also reminded the jury about what Karmelo did after the stabbing, saying Melo had every opportunity to leave that stadium, but he didn't. Okay. All right. So he didn't flee. I'm trying to see the relevance of it. Okay. He told the jury that Texas law does not require that you wait until you get hit to defend yourself. Ask yourself, has the government ruled out your reasonable doubts? Is it reasonable to worry that these kids might jump in, that Hunter might pop up in to defend his brother? Howard then began to address motive, saying Karmelo had no motive other than that he felt was in danger. Okay, here's the thing. The motive is not that big of an issue in this case. I think motive gets really blown out of proportion sometimes. But let's remember that the kid brought the knife to the track meet in the backpack, concealed, and then put his hand on it as the confrontation was going. So I'd be a little leery if I were the defense attorney about talking about motive. I think there's some evidence out there that doesn't work real well for you. The law requires that you put yourself in Melo's shoes. That is true. He spoke about Karmelo seeing his friend under the memorial tent, a friend who had previously testified in the trial that he was very intentional in his bias, willing to lie even about how close they were. Howard again addressed the conflict under the tent, saying that there was a chorus of people, but it's too late to turn your back because what's going to happen? I don't know. If I look at you repeatedly, tell you don't touch me, I have something in my bag, that is the ultimate warning to back off, Howard said. Okay, so that was the defense's closing argument. And again, I'm a little perplexed at what's going on here with that. Now, I want to address an issue before I get to the prosecutor's closing argument. All right, and this. There's a lot of people speculating on X, what I call Twitter still, that the defense intentionally tanked this case so that they can get an appeal on ineffective assistance of counsel. Okay. I believe that those opinions are coming from, pardon my language here, people who don't know what the hell they're talking about. I have no reason to believe that this defense attorney is not trying his absolute damnedest to defend his client. The problem is, as I said yesterday, you can't make chicken salad out of chicken shit. And he has a very, very difficult case in which none of the evidence seems to be supporting any of the whatever the defense theories are. Number two, if an attorney were to walk into a courtroom and intentionally tank a case, that bar association, the Texas Bar Association, would have that attorney's bar license so fast it would make his head spin. Okay. Number three, do cases get flipped on appeal on ineffective assistance of counsel? They do. They absolutely do. But here's what happens if a case gets flipped on ineffective assistance of counsel. The charge is dismissed and the person goes free? No, they don't. No, the verdict is overturned and we set it again for trial. Okay. And you talk to any defense attorney, you can talk to any prosecutor, they will tell you that on retrial, prosecutors clearly have the advantage because they have already seen what the defense theory of the case is. It's usually pretty easy to figure out what the prosecutor's theory of the case is because it's all the evidence that they're going to dump on you. And in this case, I think the prosecution has been very, very clear about what their theory of the case was. I think they've been actually quite consistent in what their theory of the case was. So anyone thinking that this is some kind of a 4D chess game that defense is playing here, hey, let's tank this case, let's tube this thing, and then we'll get it flipped on appeal, and that's how we're going to win. That's just not the way it works, okay? It's just not the way it works. So, okay, 22 minutes ago, prosecution begins closing statements. But remember, prosecution is not giving a closing argument. They have waived their closing argument in this case, which means they are now doing a rebuttal argument, which is I get to take all my allotted time and pick off everything that the defense attorney just said during their closing argument. Do not let them turn a threat into a warning, Worski said. Do not let them turn taunting, provoking threat into some kind of benign warning. A very impassioned Worski told the jury that what's not important is motive. What should be is mindset. Not a bad argument. He took a knife to a track meet. He had a secret. He kept it hidden. He was the only one with a knife that day. He was always going to come out on top that day. You don't get to meet a shove with a stab. That really is the theme of the case right here. You don't get to meet a shove with a stab. Do you get to meet a shove with another shove? You do. And this is only if, in fact, Karmelo actually has the right to use self-defense at all. Because remember, if a jury finds that he was the person who provoked the incident, that he was the provocateur, that he engaged in provocation, then by Texas law, as many other states call it the first aggressor standard, Mr. Anthony is precluded from claiming self-defense at all. You can't pick the fight and then later claim you acted in self-defense. That's how the first aggressor standard, or as they call in Texas, provocation, that's how it works. That is really the theme of the case. You don't get to meet a shove with the stab. Worski told the jury the case is simple, calling it an unjustified provoked murder. That's what you hear from all of these witnesses. You can't provoke yourself into using deadly force. I know it's not easy, but I'm telling you, it's crystal clear. Why didn't you just walk away? Worski asked the jury, asking after Karmelo was asked to leave the tent. You had a chance to walk away and abandon the encounter. By the way, under the first aggressor standard, if a person tries to walk away, and it's pretty objectively clear that they're just trying to leave the confrontation, and the other side continues after them, then they may no longer be considered the first aggressor, and they may be able to use lethal or force. And then, of course, if you're encountered with unlawful lethal force against you, you could use unlawful lethal force. The problem here is that there is not one iota of evidence to suggest that Mr. Anthony was encountered with unlawful lethal force being used against them. So even if a jury believes that Mr. Metcalf had no right to shove him, had no right to tell him to get out from under the tent, the question still is going to be, was the use of force by Mr. Anthony proportional? I don't believe it was. We have alleged two ways to commit murder, Worski said. You don't have to agree on which method, intentional or clearly dangerous act, as long as the state has proven it and it is unanimous. This is an interesting thing that I've actually not been a fan of, having been a defense attorney, which is that a prosecutor can charge a case conjunctively. We believe he committed crime A by doing either X or Y. A jury does not have to be unanimous as to whether he did it by X or Y. They just have to be unanimous as to why he did it. So the argument from the prosecutor is a correct legal statement as to what the state of the law is. There was a theory that got floated out during this trial that I think went over like a lead balloon, which was that Mr. Metcalf had accidentally impaled himself on the knife. Apparently, there was a lot of audible gasps in the courtroom when that theory was introduced. That is usually not a particularly good sign if you're the party introducing things. When the gallery and the jury is gasping, probably not a good thing. I will tell you that candidly, to give you an idea of just how bad that theory was, the prosecutor didn't call any rebuttal witnesses. If that theory had any kind of teeth, what you do is you call the medical examiner back to the stand. And the medical examiner, who obviously has a lot of expertise in all sorts of wounds, stab wounds being one of them, would talk about the amount of force that it would take to take that knife through the sternum and into the heart as far as it went. And I don't mean to get graphic here, but it's a very deep wound, okay? And it would require a lot of force. And so a person lunging forward and impaling themselves on the knife could happen. That could happen. The depth of that injury, the depth of that wound is almost virtually impossible to do through self-impaling. And so, I don't know, man. You're just kind of throwing rocks at the moon at that point. All right. He told the jury, the prosecutor told the jury that Karmelo had a guilty mindset because of the way in which he fled after the stabbing. He began to remind the jury about the evidence and witness testimony, particularly as it pertained to provocation. I didn't want to talk about it, but I have to right now, Worski said. He began to reference specific witnesses and their statements about how both Austin and Karmelo's demeanor on the day of the stabbing. He referenced how Karmelo was described as looking suspicious, that Hunter was allegedly uninvolved, and that Austin, though frustrated, did not want to fight. And let's remember, there was testimony from multiple witnesses that Mr. Metcalf had said, I don't want to fight you at a track meet. I don't want to fight you at a track meet. All right. We went through all of the witnesses' testimony and ultimately concluded with the defense witness, who actually turned out to be a prosecution witness. That's a good way to kind of ring that bell. Let that be the last thing. The case presumably now, let me see if there's another update. But at this point, the case presumably has gone to the jury. They have been given the jury instructions. Yeah, there's no further update. So I would assume at this point that the case has gone to the jury. It is, what time is it down there? It's 10. Okay, so it's about 11 a.m. down there. I believe they're 2 hours in front of us. We're at 9 a.m. out here on the West Coast. Whether they're going to have the jury deliberate and then maybe break for lunch, or have the jury do an early lunch, break for lunch, which in this case with the jury sequestered, it's probably box lunches getting sent into the jury room. I'll be honest with you, folks. I think that a quick verdict here, it depends on cases. Sometimes I've tried cases where, hey, a quick verdict is good for me. I've tried cases where a quick verdict is bad for me. It just kind of depends on the theory of the case and what each side is working with. I think a quick verdict on this case is very bad for Mr. Anthony. I think if you're the defense attorney, you are hoping that this jury deliberates through today and possibly in tomorrow. That would be signs that perhaps they are caught up on something, or perhaps they are maybe considering murder versus manslaughter. I think if we get a verdict sometime this afternoon after the jury deliberates for a couple of hours or something like that, it's going to be a very, very bad day for the Anthony family. Mr. Anthony, if he is convicted, will be remanded into custody today. The bond will be revoked. He will be remanded into custody today. He will remain in custody until sentencing. When that occurs is going to depend on the county and the court schedule and things such as that. As everyone has stated, he is looking at a range of 5 to 99 years. I don't understand Texas law about how you could have a range that broad, but hey, it's Texas. They get to do whatever. We got people suggesting that the jury will be back in 2 hours. 2 hour verdict on a case like this would not be good for the defense. So we will be back online probably this afternoon. I actually have to go play lawyer this morning for a little bit myself. I got something to do here in a few minutes, and then I got another thing to do this morning. And so I'm going to squeeze in another live cast probably right after the verdict goes by. And then we'll probably have another video either later tonight or tomorrow. Might have to remind all of you what happens if you accidentally drive into a violent riot, because I do believe that there are going to be some people that are going to be less than happy about this verdict should Karmelo Anthony be found guilty. I am not going to make predictions because I'm not a sports book here, okay? But what I am going to say is if I was a casual observer of this trial with my understanding of how criminal trials work, yeah, if I was on the defense team right now, I don't feel good. There are stories kicking around on X that the Anthony family looked incredibly distraught both yesterday and today, that they kind of see the writing on the wall. A lot of other vicious rumors rolling around out there about how we even got this far into the system and was the Anthony family taken advantage of by other people. I'm not going to get into any of that speculation. I'm just not, because at the end of the day, we're going to focus on the application of elicited facts in the courtroom and how they apply to the law. That's how trials work. We're not really going to get into the race issues because I just don't want to go there. And I don't think that this case really has much to do about race at all. Okay. Listen, we will be back later this afternoon. What I typically do when we get online live like this is I kind of stall for a few minutes and let a few people filter in. I want to thank all of you who have tuned in live right now. I appreciate it very much. Just in case you're new to Washington gun law, we are Washington gun law. We usually cover Second Amendment litigation, Second Amendment legislation, as well as things related to self-defense. We don't normally armchair quarterback trial work, but there was just a lot of, I don't know, ridiculous stuff flying around on social media, people who just really didn't understand what the hell they were talking about. I always find it amazing how everyone becomes a trial attorney expert when a trial went on. They're a constitutional expert. I got in-laws that have been infectious disease experts, constitutional experts, immigration enforcement experts. They just kind of float from topic to topic. So I'm not claiming that I have all the answers. I'm not claiming that I got a crystal ball here that can just predict everything, but I have spent way too much of my life in a courtroom. I have tried a lot of cases, so I kind of understand how this works. So in the meantime, we're going to keep posting on X about any other developments. We believe the case to be with the jury now. We believe that there will probably be more updates later today. And as soon as we have those updates, we will let you know. I want to thank everyone who tuned in right now. Thanks for watching. You all stay safe, and we'll see you shortly.